This should be a great discussion, assuming, of course, I refrain from making any terrible dad jokes. This is Navigating Credit Agreements, the episode number 1 of the Financial Poise webinar series on leveraged finance. You can read more about Financial Poise on slide 42. Our panelists today are Steve Remelius, a Managing Director at CIBC US in Chicago, Illinois, and Krista Mancini of Jones Day in Miami, Florida. And I'm the moderator, and my name is Lewis Grimm of Jones Day. You can see our names on slide 6, and you can read our bios on slides 35 to 37, but neither Financial Poise nor we intend for this to be an infomercial, so you don't have to listen to me read bios. If you want more information about us, just look at our bio slides. About the slides, I'll try to call your attention to slides that are relevant to whatever we are talking about, so you can take notes if you like, but don't worry if you're listening but not watching this webinar. You'll be just fine because the slides are not critical. Financial Poise webinars are supported in part by sponsors, and the sponsors for this webinar are on slides 3 and 4. And our Sunburst Digital, the maker of Type to Learn typing app for children K through 12, Max X Asset, which provides turnkey solutions to online auctions, and Mood, an online retail cannabis dispensary. Last thing before we begin, slides 5 and 33 contain a disclaimer. You are not our clients. We are not your lawyers. What we do here today is for your general education and not for you to act on without appropriate advice. And without further ado, here we go. So, Krista, generally speaking, what are the different types of credit facilities that you see in the market?
So, just to walk through, some of the different types of facilities we see, and just as an introductory note as well, these aren't mutually exclusive to documents. It doesn't mean that if you have a term loan, you can't also have a revolving component. We'll talk about incremental facilities. You often see those in documents with a term loan and a revolver, or a delayed draw term loan. So there's, it could be one standalone facility, or it could be a mix. So when we talk about term loans, the key feature there is that it's a lump sum funded at closing, and or the initial funding date. And once that amount is repaid, it can't be redrawn. And that's a good segue into revolving facilities then, where if more, think of it like a line of credit or a credit card. You can draw up to X amount of the revolving commitment. There'll be a cap at whatever the upper tier of the commitment is. If it's a $1 million revolving facility, you can draw up to $1 million. You could draw less than that. You could draw 500 and then repay 500 and then redraw it. You can repay and redraw on a revolver. And I guess just to quickly hit on delayed draw facilities. So that would be a subset of a term loan, where we talked about that a term loan being drawn as a lump sum on the initial funding date. Sometimes you'll see delayed draw features of a term loan to make it a little bit more like a revolver, in the sense that it doesn't all have to be drawn on the first day and not in one lump sum. Usually it's capped at, a certain amount of draws that's negotiated depending on the particular needs of that business and that deal. And there might be caps on the amount that can be drawn at each individual draw, but it gives some flexibility for a term loan commitment to not require it to be funded same day, that there can be ongoing draws, but again, retaining the term loan feature that once those separate draws, if they're repaid at all, they can't be redrawn. And usually there's an overall cap too on the commitment time, where you're not typically going to see a delayed draw term loan commitment hanging out for 5 years. Usually it's going to be a somewhat short window you have to draw on, and it could be 6 months, it could be a year. You might see 2 years, even depending on what the basis is for the deal. But there's usually some time restrictions as well, and a fee that goes along with that to keep that commitment open. Incremental facilities, just at a very high level, because I think we're going to get into those in more depth later on in the presentation. But that would be, sometimes you hear them referred to as an accordion feature, as like an increase to a revolving facility. This allows you to tack on, under the same form of documentation, It's not committed, but it gives lenders and borrowers the option, if they so choose, to add additional tranches of term loans or to increase the size of the existing revolving facility, for example, later down the line, once the credit agreement's already been executed. You can add it under the same documentation. Bridge facilities, we think of those as, typically it's a way to finance like a large acquisition, and they have pretty specialized terms. Usually it's like if a large acquisition was announced, but they need time to line up the more permanent financing, or maybe just based on market conditions, it wasn't feasible to get permanent financing lined up on terms that are, acceptable to the borrower at that time. But you need some kind of proof of funds in order to make a large scale acquisition go forward. To commit to that acquisition. You'll see a bridge facility, usually not the best of terms for the borrower, and that's kind of the point. Usually they're incentivized for the bridge not to fund even. It doesn't necessarily mean it's funded financing. It might just be a commitment. If the permanent financing that's being negotiated in the background can't get off the ground, or they can't reach a deal, you have to fall back on the bridge. And the bridge financing may actually fund, then it's usually not favorable terms. The pricing is going to tend to be higher than what you're looking to get in the permanent financing. There's usually like a lot of penalties, like the rate will step up the longer the bridge is outstanding. Basically a lot of incentives for the borrower for that bridge never to fund, or if it does, to get rid of it as quickly as possible. It's meant to be exactly as the name implies, just a bridge to a more permanent financing solution. And then some of the things that definitely impact just the way we go about documenting facilities and what the main considerations for borrowers and lenders are going to be. Obviously one of the key items is whether it's secured or unsecured. The terms of an unsecured facility are going to look a lot different than secured. And obviously in a secured facility, you're going to have, tons of collateral documents and all those considerations in the background for the, what the collateral package is going to look like. And, then if we get into lien ranking, if you have a first lien and second lien facility, or there's multiple creditors that have a lien on, the same piece of collateral, you get into intercreditor issues. That's when we would have intercreditor agreements, subordination agreements, and these are all just different ways of whether it's, we talk about lien ranking, whether it's different priorities to the same piece of collateral, or, maybe it's not lien priority, maybe it's payment priority. And so we have a senior tranche and a subordinated tranche of debt, or a mezzanine facility, which would typically, so when we talk about mezzanine, you think of it as kind of a in between debt and equity. Taking its name from, like a mezzanine floor in a building, it would typically sit above the operational entity of the enterprise. And it's lending based on not the assets of the entity. A lot of times it's just a holdco. It's based on the projected cash flows that entity is going to receive from operations that sit below it. So these are all just various tools that, and options that borrowers and lenders have to try to structure the deal. Obviously this was very high level. And, it comes down to the specific needs of the enterprise and what the market, a lot of these things too, we see, can get really hot in the market for certain times. And you see, mezzanine structures, in certain industries are, really hot at times versus not so much in others. And, it really depends on, market forces and just the particular needs of the business. There's no one right way to do it.
Great, thank you. So Steve, it's often said that lenders work on a cost plus basis. What does that mean in terms of the credit facilities?
Yeah, there are a handful of provisions that reflect this, and essentially the lenders utilize other indices to base the cost of borrowing, as well as to base kind of expense reimbursement. So there's a number of things in this, that we'll talk about through this presentation that kind of relatively borrower friendly versus lender friendly. These are the provisions. This cost plus concept is more on the lender side. So from a simple level, the borrowers reimburse the lenders to prepare the legal documents and conduct diligence, right? It's sort of as basic as that. Further, if there are changes in laws or taxes, or anything like that, the lenders basically have a right to true up. If those types of provisions change, that would be adverse to them. There are some other, indemnity provisions and things like that that you will find in credit agreements that would also be in the lender's favor. Certain actions that could take place, the lender is indemnified not to pay those. And then from the indice perspective, I talked about those are usually, there's based on a spread to an index that results in kind of that cost plus concept. So first off, you have a fixed rate versus a floating rate loans. Most leveraged finance loans in the market, whether you're doing small ones or large institutional ones, are typically floating rate. But your high yield bonds, things like that might also be part of the capital stack. Krista talked about the different tranches, right? So one tranche, a mezzanine tranche, might be a fixed rate, whereas your senior tranche would be a floating rate. And in that floating rate case, there is a spread in addition to your index. The index generally is SOFR, but there are also other, in the US, the index is SOFR. But in other countries, there's can be a different index. And this is sort of but that's the most common. And then you have alternative base rates, prime rates. Prime is another option that a borrower could borrow on as an index. The credit agreements will build in language for alternative base rates if for some reason those didn't become available. We had this in the last few years when there was sort of the sunsetting of LIBOR, and that transition to SOFR, that those were built into credit agreements to account for that. And those would kind of be part of that alternative base rate option that the borrower might be able to use. And again, then the borrowers charge SOFR plus 300 basis points. And that's kind of getting back to that cost plus. You also have interest rate floors, similarly more of a lender protection, such that you wouldn't end up in situations, you make a loan, because these are floating rate loans, you make, a 5-year, 6-year duration loan, and you're sort of basing your spread and your all-in yield as a lender based on certain assumptions. And if those change materially, you may not be protected. And the interest rate floor is one way that lenders utilize as a means to kind of manage that cost plus model.
Great, thank you. So, Krista, when you're drafting a credit agreement for an acquisition financing, what are some of the considerations that might impact the structuring?
So I think one of the first things we would think about is whether we're dealing with a public or a private acquisition, whether it's a public company merging with another public company, or maybe they're going public in connection with an acquisition, because that's really gonna affect, and we'll talk about a lot of these provisions later on in the presentation, but that will affect how in-depth a lot of the representations are. It's going to change the covenant package. And a lot of this stems too from, really it's just what the market demands, but it's also consistent with the merger agreement or the purchase agreement or whatever the M&A document is. And obviously there's a lot of interplay whenever we're doing an acquisition financing. We have to work very closely with on the end, when you're just from the loan debt perspective, would have to work very closely with the team documenting the actual merger or acquisition, because you need to make sure that the whatever documents are on the M&A side are consistent with what's being put in the loan agreement. But typically the representations and warranties, for example, in a merger agreement, if we're talking about public companies, are going to be much more broad and loose than they would be if it's in a private context. The idea being that this information is publicly available, and there's an even playing field based on what's already been disclosed publicly based on SEC requirements. you can go look it up, as opposed to, you know, they're not usually going to give you more than what's been publicly disclosed, with some exceptions for, you know, particularly negotiated items. But you know, so just on the face of the credit agreement, it's going to look a lot different if it's a public company deal versus private. You know, just given the nature of some of the disclosures and, you know, some of the more relaxed covenants and reps that you'll see if it's in a public context. You know, in terms of structure, you know, we have to think about what entity actually serves as the borrower too, and where it makes sense to actually put the debt. And it can change after the acquisition too. A lot of times we see, you know, just an acquisition vehicle set up solely for the purpose of, you know, acquiring the loans, you know, so that it has the cash to actually make the acquisition. And then, you know, maybe it's pre-baked already into the credit agreement that, you know, another entity is going to succeed as the borrower entity, you know, right after that initial consummation of the acquisition. There might be multiple borrowers. Maybe you leave on the initial, you know, acquisition co as well, depending on the needs. You know, if it's a merger, you know, we often see like a merger sub entity as the initial borrower, and then it's going to be, you know, that entity is going to be merged out of existence in connection with the actual merger. And this, you know, particularly if it's a public company context, you know, anytime it's a public company merging with or any kind of acquisition activity with public companies, it's almost always going to be a merger. There's just too many stockholders to make any other thing practical any other way. So, you know, when we think of like merger vehicles and, you know, how those work in the context of who's going to serve as the borrower, what's that going to look like going forward, who's going to remain on as the borrower, you know, or two, I know we have on the slide up here, if it's friendly or hostile, you know, we don't see it certainly happens, but, you know, I think more often than not, the type of activity we see is friendly. But, you know, if you consider in a hostile situation, you're not going to have the cooperation to get, you know, all the diligence efforts and such for the target. You know, so in that case, you would think, you know, that the debt's probably going to have to sit higher up in the structure. It may be harder to access debt in that kind of example too, or at least to the volume you need. There may need to be an equity component or some kind of other alternative financing there. You know, if you can't, you know, fully get access to, you know, to the records and everything else and management cooperation at the target level, you know, to get lenders comfortable to get a sufficient amount of debt, you know, to back, you know, the creditworthiness of a target. You know, so that would also impact just whether or not it's friendly or hostile would impact a lot of times where the debt's going to sit. And then too, I think just taking a step back in an acquisition context, you know, one of the main things you want to think about is, you know, what are we buying? And, you know, obviously that's more on the M&A side in terms of what the actual, you know, how the business runs and what those operations are, what its EBITDA is, all of those considerations. But, you know, when we think from a debt perspective, like what kind of debt does the target and its subsidiaries, what do they own? Or excuse me, what kind of debt do they have on those assets? What other facilities are in place? What's the subsidiary structure? You know, are we looking at, you know, one U.S. entity with a bunch of foreign subsidiaries? And is that something that, you know, the lenders of the acquisition financing are going to have to deal with? Are we going to have foreign subsidiaries? Are we going to designate some as unrestricted? You know, if we have an entity that basically behaves like an unrelated entity and we don't want that wrapped up in the, you know, in the covenants and, you know, it needs a little bit more flexibility, maybe it'll need to be designated as unrestricted. You know, so you definitely need to take a step back and look at the big picture of, you know, the structure chart of the target, you know, and what's coming over in that acquisition, and, you know, paying close attention to the current, you know, debt capital structure of the enterprise being acquired or that's being merged with, you know, to see what's getting paid off, what's remaining in place. You know, maybe there's smaller facilities at some of the subsidiary levels that aren't meant to be paid off and that are surviving the acquisition, you know, and then you have to think of, you know, potential, you'd be structurally subordinated to debt that's surviving at a subsidiary level where those creditors are just closer to the assets at that particular subsidiary. You know, if you're the lender, 3 or 4 entities above, you know, above that subsidiary, you know, these are, and that may be perfectly fine in this structure. It's just, you know, all things that have to be considered. That's why there's so much diligence involved in an acquisition context in particular, you know, because it's not only the entities that you're lending to make the initial acquisition, But then, you're most likely going to then be, lending and allowing that capital and the proceeds of those loans to move throughout the target entities as well.
Great, thank you. So Steve, take a step back. Who are the main parties to the credit agreement?
Yeah, so you basically have put it in two categories, no different than how, us individually would go get a mortgage, right? You have a borrower and the lender, right? Those two primary with in sort of these types of transactions, though, several layers within the borrower and the lender. And a lot of it, so, from the borrower side, it depends kind of what Krista was saying in terms of just the ultimate legal structure, right? Borrowers, guarantors, you could have co-borrowers that ultimately depend on, where the operating assets are, where the operating cash flows might be, et cetera, right? So you might have parent subsidiaries, you may have co-borrowers in that situation. In some of those situations, you have borrowers and guarantors. You may have international subsidiaries that may be parties to the credit agreement as a guarantor, and things like that. You could potentially, while a little bit more rare, sometimes maybe your ownership group, provides a guarantee of some respect, whether that's a private equity firm in a very unique situation, which that would not be that typical, but can happen if you're talking about privately owned businesses. That maybe family owned, there may be guarantors associated with that based on the ownership group. And so it just kind of depends, ultimately, like the last question about the legal structure and who that ultimately is, but it's basically the borrower. And then on the lender side, similarly, you have the lender in a single bank, single lender transaction. That's it. It's just that one party. However, there tends to be in larger transactions, syndicated transactions, there tends to be then layers of lenders. You have ultimately your lead arranger or lead left arranger, depending on that person's role. That's usually where most of the work in administrative work gets done. The logistics of, Krista talked about revolving lines of credit, things like that. The lead arranger, the administrative agent, that role, that lender would kind of manage the process, manage the flow of funds between the borrower and then the rest of the lenders. We talked about administrative agent, collateral agent as well can be a role for one of the lenders who's actually managing, potentially managing a borrowing base, which is where the revolving lines of credit are based on the assets. And there's certain formulas and things like that. They'll manage the lien process. Then you also have other roles that lenders, a lender might be documentation agent, syndication agent. Frankly, they're more marketing terms than they are actual, tasks that a lender might have or a role that they might have in the transaction. Just generally means you've taken as a lender, let's say it's $100 million transaction or $200 million transaction, the administrative agent, lead arranger is likely going to have the largest hold. And then the next, sort of set will have a title, documentation agent, syndication agent, is sort of giving them recognition for their hold in the transaction. And then some of the other types of just more logistics, swing line lender can also somewhat related to the revolving lines of credit. You may have in much larger syndications just to help manage logistics of actual borrowing, where the swing line lender may manage, the company requests a draw on the revolver situation that Krista talked about earlier, may not settle with the rest of the lenders, maybe once a week, type of thing. And that swing line lender then manages that process. That is typically the lead arranger in most cases. And then just amongst the rest of the lenders, maybe you have a large institutional, broadly syndicated credit, and there's 100 lenders in the transaction. The rest of them are just as a party, as a lender. They really have no other role, no other title, thing like that. They've lent their money or they've provided a commitment or whatever it is, and they're simply a lender.
Sure. So, Krista, what are some of the mechanical provisions that are more typical in a syndicated credit facility?
So I think one of the one of the hallmarks that, lenders are always going to look for in this, in this context, and that we see in any syndicated deal, are protections against, non-pro rata treatment of certain lenders. So, I think that's when lenders are doing their lender review of documents, and they're, they are making sure that, the credit agreement checks all the boxes that they would expect in order to enter into it. One of the main things that they're going to check, and that, we would often get questions on, is to make sure that, they are not being treated unfairly, or that the credit agreement doesn't leave open the door for them to be treated unfairly compared to other lenders, in their same position. So, the idea there being, you wouldn't want the borrower to be able to, voluntarily pay off one revolving lender's loans without also making, an equal and ratable payment to the other revolving lenders' loans. So you can't treat one lender more favorably than another. Obviously there are certain exceptions to this, and there's a lot of, there can be violence among lenders, and there can be, loopholes exploited, and, there are certainly plenty of cases where this has broken down. But, as a general rule, that's, what lenders are going to look for. And it wouldn't be surprising to have those types of provisions in there, to protect that pro rata treatment for all of the lenders similarly situated. Again, you might have some differences for, there's certain things that, you could make a repayment on the revolver ahead of a certain term loan tranche, or vice versa. If it's within different tranches or classes, that's a bit of a different story. Also, like one of the key features in a syndicated deal, which, is not controversial, it's just, you will see the language in there, that, each lender's obligations to make loans, they're several and not joint, which should go without saying, but of course it tends to be stated in the document, that, if lender X commits, 10 million of a $100 million term loan, and lender Y commits 5 million, if lender Y doesn't fund or changes its mind or anything else, lender X is never going to be obligated to fund any of that 5 million that lender Y committed. It's you are only, as a lender, you are only responsible for funding what you actually agreed to fund. And, regardless of what happens with the other lenders, regardless of whether they default, if they back out, whatever it may be, you are only responsible for your share, of what you committed up front.
That seems fair.
Let's see what else. Oh, sorry,
I just said that seems fair.
that's how we want it to work. Then there'll be some, just from like a administrative mechanical perspective too, when we're talking about a large syndicate, just to keep things somewhat orderly, and, understanding that the agent, or whoever's responsibility it is, depending on what the action is, need to communicate to a larger lender group, have everyone, if there's a borrowing, for example, absent use of, the swing line facility, like Steve alluded to, all the lenders are going to have to fund their pro rata share of that requested borrowing, which, typically is going to go to the agent, and then the agent's going to disperse the amount, once they've gotten the funds in from the other lenders. So, we see, requirements for, like, borrowings have to be in a minimum amount, in certain multiples of X dollar amount, just to kind of keep things more orderly and consistent. Sometimes you see caps on the frequency of borrowings, so that, we're not going through this process every day of the week, because it can get cumbersome, especially depending on, the size of the syndicate. That could be a pretty cumbersome effort, if, there were daily borrowings. And let's see, just one thing to touch on, actually, because it comes up for us a lot too, is promissory notes. And I feel like there's always a lot of confusion around those. And different types of lenders look at them very differently. So, the promissory note, there's no magic to the actual document. When we think of, the credit agreement itself documents the loans, and everyone's obligations to fund, and the borrower's obligations to repay those loans are all in the credit agreement itself. You'll typically see, a little one-pager promissory note, not highly negotiated. That's basically just, the borrower signing an "I promise to pay" statement. They're usually an exhibit attached to the credit agreement. years and years ago, it was customary to always get a promissory note. Now it's not required from like a legal documentation standpoint, again, because it's all documented in the credit agreement. But you'll see certain lenders still, particularly bank lenders, press for promissory notes. And it's, typically because if they want access to capital at, the discount window at the Federal Reserve, a lot of times they have to pledge, to show as backup for that loan, the actual promissory note. But even that has changed. Like the Fed doesn't actually require the physical note anymore. You can be on a no note basis for a loan. But then you get into if they don't have the physical note to produce, then a lot of times they need to be there needs to be like a UCC filing against that bank entity. If they can't produce the physical note at the discount window, banks, obviously, some of them don't look favorably upon that. They'd rather just have the note. I guess this is a long-winded way of saying notes are not actually that critical, but you will see a lot of bank lenders in particular in the term loan A market. It's not customary to give them in the term loan Bs. They get very worked up over notes. Like banks will they want their original note when the transaction closes, and they will press whoever they have to press to make sure they get it. And it's not a controversial item. Borrowers are happy to sign them and deliver them. It's more of just an extra paperwork item. But it is one of those, I always find it interesting that, kind of the trend of how notes came to be and how they're really not legally required anymore, but it is still such a touchy subject for bank lenders in the term loan A market that, it's just my little nerdy point that I find interesting.
Don't take away their notes. So Steve, what are the different types of lenders, and how do their economics differ?
Yeah, so Krista kind of introduced some of the concepts that you start to think about or talk about: banks versus non-banks, pro rata, term loan A, term loan B, et cetera. And so you have, kind of on almost like a tiered scale where probably your least expensive, and this is not always the case, this is sort of generally the case. The least expenses are expensive are your bank type structures that are also known as pro rata structures or pro rata lenders. That just goes back to the concepts we talked about. Krista introduced sort of as you have a share across revolver, term loan. Everyone comes into a transaction at a certain percentage, right? A lender holds 10% or 15% of an overall total transaction, right? That's their pro rata share. They get that, they have their pro rata voting rights, pro rata, if there were ever a troubled situation, right? The repayment is on that pro rata basis. That is primarily, not exclusively, but primarily the bank market. And really in those cases, and why I say that the economics there are that it's a little bit cheaper, banks generally are viewing it, right? Banks don't make money simply by lending. Certainly that is the primary aspect of a bank, but there are other products, services, solutions, et cetera, that banks are generally offering to their clients. And so they make loans with the expectation to get deposits, to get international foreign exchange business or capital markets revenue, all different types of, sort of cross-sell, if you think about it from an operating business perspective, even as an individual, right? It's the same thing as an individual. A bank doesn't want to give you simply a credit card. They want you to open a bank account. They want you to get a mortgage from them. So banks kind of take that same approach, and then ultimately they upsize their economics through those cross-sell. And then it ultimately means the loans are priced a little bit lower than sort of an institutional or non-bank market. Most of those structures are referred to as term loan A. Again, usually term loan A, you have covenants that we're going to speak to. Hopefully we'll get some time with that. As well as amortization, the repayment of the loan typically is a little bit more per year than a term loan B. So then you move into the term loan B structures, which are primarily institutional lenders, CLOs, different types of funds, insurance companies, finance companies, et cetera. Those are generally a little bit more expensive, than a bank pro rata transaction. They're typically term loan B structures, 1% amortization, more flexibility. Oftentimes in that market right now, there are no covenants to the term loans. They call them covenant light, but really they have no financial covenants to them. Sometimes there can be covenants to them, but they'd probably still be considered covenant light. They offer flexibility. The duration is oftentimes a little bit longer, maybe 6 or 7 years, versus a pro rata bank transactions that are typically 5 years. And then you have the non-bank market, or that it's often referred to in many different terms. Non-bank, private credit, direct lender. Is just another solution. Maybe not always. They are playing in this space now, but maybe not as large as what the institutional market can do. Most of the institutional lenders, they are arranged by banks, not always, but often arranged by banks and then sold and distributed to an institutional base. Whereas direct lenders are generally holding it for their own funds or syndicating to other direct lenders similar to themselves. And then the economics are a little bit different. Banks have no problem providing revolvers. Those institutional lenders, the non-bank lenders, generally prefer not to offer the revolvers because there is a capital associated with it. They don't have other business to offset ultimately.
Got it. So, Krista, maybe could you briefly describe how the interest mechanics typically work?
Yeah, so typically there's an option between a fixed rate or a floating rate. And so the borrower would make the election of whether they want the base rate, usually based on like one of the lender's prime rates. I think Steve touched on that earlier, or whatever the benchmark variable rate is under that credit. It's typically, it used to be LIBOR as the kind of the market standard. Now it's SOFR. It can, there's other options too, but it as a general rule, it's most likely going to be SOFR if we're talking about a benchmark variable rate, at least in the loan context. And so you would have a choice between those two rates typically, and then on top of that, there's going to be a spread. The applicable margin on top of whatever the baseline interest rate is. The applicable margin can be fixed or it can be based on a grid. So it might just be the SOFR rate or base rate plus 5%, or it might be SOFR or base rate plus a margin based on a leverage grid or based on a ratings grid. Where as the borrower's credit rating gets better, your applicable margin and your pricing goes down. Or as your leverage ratio gets better, you're less levered, your pricing goes down. So that would be a grid-based option as opposed to a fixed margin. And then in terms of, there's really no magic to selecting the rate, whether a borrower elects base rate or the benchmark. Typically, they're usually always going to elect, if given the option, the benchmark rate, just because it's in most market cases going to be less than, it's just cheaper than the base rate. Usually if a borrower is electing base rate, usually it means something has gone wrong, meaning they missed a notice period to get the benchmark rate lined up, or it's only meant as a short-term borrowing. For example, when we talk about the swing line facility, that would have to be drawn at base rate because it's faster access to the loans in that case if it's a base rate. You need to typically need to give the lenders around like 3 business days to line up a SOFR draw, as opposed to base rate can be accessed, oftentimes same day. And then you can convert from one to the other. You either continue at your benchmark rate, or you can convert from, if you later decide, maybe you ran out of time and for the notice period, you needed quick access to capital. So you got a base rate draw the next day, but then, it's too expensive. You want to switch to a more favorable pricing of a SOFR rate loan. You can put in a conversion notice. Usually you need about 3 business days for that as well. And you can convert the loan from base rate to SOFR. And then just quickly to touch on the interest periods, for the bench rate, for the benchmark, variable rate loan. This is the same as LIBOR as well. SOFR follows the same interest periods with, I think, just a few exceptions. We see 1 month, 3 month, or 6 month, or, usually the typical options offered. That's the forward-looking SOFR rate. So you would elect at the time, if it's a term SOFR rate, whether you want, as the borrower, you want 1 month, 3 month, or 6 month. There's some other options as well, but those are the standard ones we typically see. And then that rate then is whatever 1 month SOFR is on the date that you elected that borrowing, or the date that it's drawn. That 1 month rate is locked in then through the duration of that 1 month interest period. And, at the end of that interest period, that's when you would settle up the interest that accrued over the preceding interest period. And, if it's base rate and it isn't a forward-looking, term rate, typically, the credit agreement's going to provide that you have to periodically pay off accrued interest either monthly or on a quarterly basis. It just depends on the deal.
Got it. So Steve, what are the main ways in which loans are repaid or prepaid?
Yeah, so I'm going to focus on the term loans because Krista kind of talked about the mechanics of a revolver that work a little bit differently, but most of the time this applies mostly to term loans. And so there's a variety of sort of ways, whether it's optional, required, voluntary, et cetera. Primarily where your starting point is what's required, right? So you're just basic amortization, just like you get a car loan or mortgage loan or anything like that. You have set payments per month. These are usually P plus I, so principal plus interest. So the principal is set. And primarily term loan B, as I referenced earlier, really refers to 1% per annum. And kind of like the interest payments, Krista said, usually those are payable monthly or quarterly, those payments. And then in the pro rata market, you often see term loan A, which is usually 2.5% per year and above. Those are your required payments. You also have sort of the required regularly scheduled payments. You also then have other prepayments that could be optional, versus mandatory. In sort of the voluntary way, this is ultimately becomes a negotiating item on the front end of a credit agreement. You decide between the borrower and lenders how they're going to be paid, right? If a borrower is performing exceptionally well, has excess cash, and they decide like, hey, I want to prepay my debt, they have options to do so, generally speaking. Most of the case in the middle market, et cetera, there really are no penalties to doing so. There are certain aspects of the market. There are call protections for that. Maybe it steps down, kind of what you often refer here in the market, 3-2-1, right? Within the first 12 months, 3%, next 12, 2%, next 12, 1%, et cetera. Some of that goes to sort of the institutional lenders that they really view the loan as a fixed income solution that they are providing to someone, right? So they base that into their upfront decision. And so they want some call protection on that. But generally speaking, in sort of lower middle market, you would not see those call protections, and they can make payments whenever they want. And it depends on the credit agreement when you've negotiated. Sometimes a voluntary prepayment can be applied any way the borrower wants to apply it. Maybe they want to prepay the payments versus the back end of, the back end of the term loan. That may be at their discretion, depending on what the credit agreement says. You then also have mandatory prepayments. So if they sell assets, if maybe they have a divestiture of a particular business, if they raise equity, things like that. Some of those may have mandatory prepayments where they are required. And again, it determines whether it's mandatory, but then there's also, then you'll come to agreement in the front end about how those are applied. Again, similarly, maybe that gets applied to the back end, which would be referred to as inverse order. You could also be pro rata, meaning if you make $1 million in payment, it's spread equally or spread based on the scheduled payments over the remaining life of the loan. You also have direct order, where they're effectively prepaying the next several payments that they might have. And then lastly, there is very unusual provision, but sometimes gets used where lenders can reject prepayments. This is mostly the case in the sort of institutional market, where lenders again have just they would prefer not to be paid back. They want to continue to get their yield, and it could be allocated to potentially other lenders.
Sure, thank you. So, Krista, how do the amendment provisions of the credit facilities work?
As a general rule, the default rule in the credit agreement typically is to amend a provision, you would need required lender consent, which is going to be a defined term. It might be called requisite lender, required lender, whatever it's defined as, which oftentimes is just simple majority. And then if you look at the amendment section, that's the starting position. And then there's going to be a bunch of exceptions to that rule where, maybe it's a lesser required threshold, or, only certain parties have to consent, or, what we call the sacred rights, and, the items where in order to amend a certain provision or take a certain action, you would need a higher level of consent. And that might be unanimous lender consent of all the affected lenders. Sometimes we even see a different terminology for, if you have required lenders, maybe defined as a simple majority, there might be something called specified lenders. Again, all the terms just depend on you. It could be called a variety of defined terms. There's no magic to the actual term selected. Where maybe specified lenders is, 2/3 lenders, for certain items that would require a higher threshold. So, most, again, the default being most things only require, a simple majority consent of the lenders. And then when we talk about the sacred rights, that's the types of items like decreasing the pricing, extending a maturity date, modifications to like the nuts and bolt money provisions of the document, anything that affects pro rata treatment of lenders, like we talked about earlier, like one of those sacred rights for lenders. If you wanted to amend the pro rata sections of the credit agreement, the waterfall or the application of mandatory prepayments or something like that, to say that, a certain subset of lenders is going to get paid off ahead of everyone else that wasn't in the document on day one, you're not going to be able to do that. That would be a sacred right. You're going to need, depending on what the document says, either unanimous lender consent, like consent of every lender, or consent of each affected lender. That's a key distinction, actually. There's some provisions where it won't matter as much because you figure, every lender is arguably affected by a change to a certain provision. But in a lot of cases, it's different, to say you need unanimous lender consent, hard stop, versus consent of each of the lenders affected by the proposed modification or amendment. There's going to be daylight between the two. If you let's say you want to waive a certain fee that was only applicable to the revolver, then you typically can't, reduce or waive a fee without, that would be one of the sacred rights. Why would a lender that's only a term loan B lender in the deal and has no piece of the revolver, they shouldn't necessarily have a consent right over that. They're not affected by that change. It has nothing to do with their tranche of loans. It could be, if the document's not carefully drafted and it just says 100% of lenders, unanimous lender consent, you might be picking up lenders that aren't actually affected by the change and really shouldn't be able to hold up a vote. This gets a little touchy at times. Like, this is depending on what hat you're wearing, and if you're a lender in multiple tranches versus just one, or if you have other lending relationships with a certain borrower, or this gets very it can be contentious. These are negotiated provisions. But as a general rule, that's what we think of the sacred rights. And one of the key things to keep in mind is 100% versus affected lender and the difference of what that means. And then just to quickly hit, it should be in most credit agreements, but it's one thing that when you realize that it's not there, it's disappointing when you need it. Some kind of a provision for technical amendments, which actually happen more often than folks would think. If there's a clear mistake or ambiguity in the document, something that was so clearly just a typo, you probably don't want to have to solicit all of the lenders, even just to reach a basic majority consent for something as simple as that. Next thing you know, they're going to be demanding a fee to fix a typo. So it's always easier, for the borrower and the agent alike, if you have some kind of provision in there that allows those types of amendments just with the consent of the borrower and the administrative agent. Sometimes the lender group will get a negative consent right over it so that, it has to be posted and they have 5 days to reply. If it's something egregious to them and they would like to reply, but, generally it would pass then if the majority lenders don't object to it within that period. And it is truly just meant to be for cleanups. You're not going to sneak something substantive through that, but, it is just a good housekeeping item to have.
Sure. So, Steve, on a particular deal, CIBC might be the collateral agent or the administrative agent. What does that mean?
Yeah, so it's kind of really, I would say the sum of it is the logistics manager of everything Krista just talked about, right? To some degree. It really is just administrative only. The administrative agent, the collateral agent is not a trustee, not a fiduciary, anything like that. While there is generally a fee, an incremental fee associated with that role, you're sort of the, outsourced manager, kind of between the various loan parties, which could be the borrowers and then the rest of the lender group. So on the collateral side, right, that could be the secured parties, versus, administrative agent is generally all of the, sort of all of the above. And really the administrative agent, is also, really indemnified from a lot of, they're not responsible. There might be a perceived responsibility from a borrower to manage that process and get the outcome that the borrower wants, but they're not ultimately responsible. But they're really just sort of managing all of the parties, the communication between the parties, et cetera.
Sure. So, Krista, let's move to reps and warranties. What are representations and warranties, and what should people be thinking about when reviewing them or drafting them?
The representations and warranties in the credit agreement are meant to be factual statements that are true at a certain point in time. It's a snapshot. It's not an ongoing, we're going to talk about covenants next, like the actions that you have to take or things that you can't do. A representation warranty is just a factual statement, either true as of the date that it's made, or sometimes it might reference, a certain other specified date in the representation itself. They're made at the time that the loan closes, and then they're brought down at certain instances throughout the life of the loan. So, anytime you draw on the loan, you would bring the borrower would have to, and the various other loan parties as well, depending on the representation, would have to, bring down what we call bring down that representation, as of the date of the borrowing. So it's being refreshed and remade. And, I would say that when we think in an M&A context, they live and die by representations and warranties, right? That's the heart of a purchase agreement. The reps are key in that context. While, I'm not trying to diminish the importance of them in any way, I would say, as a whole, I think, the covenants are more of the meat of the credit agreement and kind of where most of the negotiation lies. Again, there's negotiation in the reps. They're important. They matter. They're definitely a key part of the deal. But compared to the M&A context, it's a little bit less critical, and the reps in a credit agreement tend to be couched in materiality a lot more than what you're going to see in an M&A context anyway. There's kind of there's just certain representations now in the market that is just understood for most borrowers that you're going to get, materiality qualifiers on a lot of these things, or even at a higher level, you get, material adverse effect qualifiers where, unless something's gone terribly wrong, you can probably still clear that representation with an MAE qualifier on it. It's a pretty high bar to cross. at least as interpreted by most courts. So, that gives a lot of leeway under the reps and warranties. But, they are, and they're deal specific too, because, if it's a borrower or a business where there's a lot of, maybe there's a intense regulatory scheme applicable to that type of borrower, you're going to see a lot more detailed reps in the context of healthcare regulations or, things applicable to a telecom industry or, whatever it may be, whatever kind of regulatory framework, is an overlay there. So a lot of times, they're not going to be, there's some reps and warranties that are, pretty consistent across deals, but, they're also going to be very specific to the industry and nature of the borrower.
Got it. So, Steve, what are conditions precedent or CPs, and how might they differ in the context of an acquisition financing?
Yeah, they're ultimately kind of in between sort of the reps and the covenants to some degree, right? They're similar to reps in some sense, but they generally are going to have specific metrics around them. And there's two scenarios really upfront, as in terms of the original funding or closing of a loan, there are conditions. Right. And it's ultimately what, a checklist of a borrower might deliver, right? What actions they might have to take, certain circumstances, their, financial metrics could be part of the conditions, meaning, the leverage, right? You've approved something and months have passed by. They still have to evidence that their leverage is not, over a certain amount. Maybe their performance, their EBITDA needs to be a certain minimum. For a new acquisition, certain equity needs to be brought in. Those types of things are generally conditions precedent to closing. And usually, like I said, a lot of those are part of acquisition financing. You also may have conditions to borrowing, sort of subsequent borrowings, whether that's a revolver or Krista referenced earlier, delayed draw term loans that could be part of either equipment financing or M&A, incremental M&A financing. Those would also have conditions precedent. Maybe you have pre-agreed financial terms, et cetera, that the borrower needs to adhere to, whether it's financial metrics, whether it's diligence provided on a subsequent acquisition, things like that. But they can apply, again, both upfront or even on subsequent borrowings. Sometimes people also reference the term SunGuard. Generally is just meaning where a buyer has specified certain reps to a seller, and then they bring the lender along that kind of that's providing committed financing with that LOI or acquisition, notice or purchase agreement that would sort of match the buyer's terms.
Got it. So, Krista, you mentioned covenants before. What are they, and what do they do? What's their purpose?
So, without getting into too much detail, the differences between, when we think of the large categories, we have affirmative covenants, negative covenants, financial covenants, and affirmative covenants are things that basically commands that the borrower and the credit parties, things that they have to do. You will pay your taxes timely. You will remain in compliance with applicable material laws. Negative covenants, you will not incur debt subject to these laundry list of exceptions. You will not, violate OFAC or sort of sanctions laws or, things related to the use of proceeds. You won't make investments other than XYZ, negotiated permissions. So it really puts restraints on the borrower and the loan parties in terms of how they, run the business, housekeeping items, gives lenders a certain amount of control, to make sure that, once the loans are made, the company's not going to be run into the ground, basically. They want to preserve the value of the borrower within the confines of the negative and affirmative covenants. It is critical. I think the reason we phrase things often as negative covenants as, you won't incur debt other than, and then, some baskets that give them a little wiggle room and flexibility, for a certain amount of capacity for certain types of debt and such, rather than the lenders laying out a clear plan of, on this date, you will borrow X amount as a capital lease for this piece of equipment or whatever it may be, because the lenders don't want to be seen as, a de facto manager of a company. That's not their role. You have to give the business enough, flexibility to still the borrower to run its own business. And, you don't want lenders exposed to any kind of liability to a third party or, any kind of a shareholder or such for, de facto managing the company. That's not the role of the lender. So I think covenants have evolved to a place where, it's a framework that doesn't expose lenders to that type of liability, generally speaking. That's kind of why we have the framework that we do.
Got it. So Steve, is there anything you'd like to weigh in on with respect to affirmative and negative covenants?
Yeah, the only thing, maybe just a couple of things I would add. We view affirmative covenants, generally speaking, are things the companies, our borrowers, are already probably doing, right? Simply providing financial statements to their lenders, very pretty basic stuff. I think Krista mentioned, right? Pay your taxes, right? Type of thing. That's for the affirmative. Where negative is much more, or the negative covenants are much more tailored, right? It's based on specific projections of a specific borrower that are generally financial oriented. Affirmative covenants may have a cure period, right? If you're late with your financial statements, maybe you get a 3-day grace period or something like that. Negative covenants depends on you. It's kind of a negotiating item, whether you have cures or not in them. In private equity backed transactions, generally there is some cure provision that has some very defined boxes around it and what they can be, right? So if you miss a financial covenant by $1 million or something like that, maybe there's an equity cure provision potential, but otherwise, absent that, there's usually no cure for them, but much more tailored to an individual borrower.
Got it. Last question, and then we'll wrap things up. Krista, what is the difference between a default and an event of default? And what maybe are some things to consider in connection with events of default?
So a default is an occurrence or circumstances that with the passage of time would ripen into what is defined as an event of default under the credit agreement. So it's a default, it's an event of default that hasn't quite ripened yet, maybe due to a grace period that's in the document, or some other, threshold that's in there. But, it's once one of those enumerated events of default in the credit agreement occurs, even if it's subject to a grace period, so it hasn't yet ripened into a formal event of default, it would still be considered a capital D default, even though it hasn't yet ripened into an event of default. But a lender would not, if there's a capital D default, you lose access to certain, flexibility under the credit agreement as the borrower and such. And there's, you might be blocked from borrowing, you might be blocked from, having your loans be at SOFR, you might have to flip to the base rate and such, but, the lenders aren't going to exercise remedies until it ripens into an actual event of default, giving effect to any of the negotiated cure and grace periods that are in the document.
Got it. I'm happy to say we have no questions from the audience. I'd like to thank both Krista and Steve for illuminating us with insights. And this concludes our webinar. Thank you for joining another entertaining yet educational production of Financial Poise. And we look forward to having you join us for the next Leverage Finance Financial Poise webinar. Thank you.